Okay, should I start?
Sir,
Sir,
she
I
will
would like to
introduce.
formally invite you for
Oh,
a few more
sure,
minutes.
sure, sure, sure,
Yes, sir.
sure. Please go ahead.
Yeah, definitely, sir. Thank you, sir. When scientific innovation is guided by a strong intellectual property and effective technology management, research truly reaches the farmer as well as the nation. Jai Hind and good evening to everyone, respected dignitaries as well as my dear participants. A very welcome to day 27 of Society for Agricultural Advancement, Research, Training and Human Innovation, Knowledge Revolution in Agriculture Nurturing Technology and Innovation 2026, our 30-day National Agricultural Training Program. On behalf of Agri SAARTHI team, it is my immense pleasure to welcome all the participants and esteemed resource person today. I am Chatrisha, along with me Vijaya. We are Agri Sadi team and will be coordinating and guiding you throughout this session. We are privileged to introduce Dr. Shiv Datt sir, a renowned principal scientist at ICAR headquarters with over 2 decades of experience in agricultural research, genetics, and intellectual property management. His expertise adds an immense value to this session today. At this point, I would like to extend a very warm and respectful welcome to Ajay Kasana sir, the Chief Secretary of Agri Sardi and Editor-in-Chief of Paras Publication. He is a visionary behind the Agri Sardi and a platform dedicated to transform agricultural education through science-based learnings and sustainable and practical learnings also, including the initiatives like the 30-day National Training Program. Yesterday, we had an informative lecture on agroforestry and biodiversity, where we have discussed the importance of biodiversity conservation and sustainable methods of wood harvesting. The session helped us to understand how to be a responsible and how to practice the resource in a responsible way and balance all the resources in the environmental protection side. So, building on those concepts, today the session focuses on intellectual property rights and technology management in agriculture, highlighting how agricultural innovations and technologies are protected, managed, and effectively transferred into a wider societal benefit. So, it is my privilege to introduce our distinguished guest, Dr. Shivdat sir, a renowned expert in genetics and plant breeding and agricultural technology management. To enlighten us to the important theme, we are honored to welcome Dr. Shivdat sir, a principal scientist with over 23 years of rich experience spanning research, teaching, and strategic management in fields. So, in genetics, plant breeding, molecular biology, and biotechnology. Notably, he brings over 15 years of specialization in these experiences. He has international research exposure, having worked as a postdoctoral fellow in genetics at CSWR University, Ohio, USA. His professional journey is including serving as a scientist, junior plant breeder at CAU Impal, and later as senior scientist genetics at ICAR CAZRI Jodhpur. Currently, Dr. Shivdat sir is working as a principal scientist at the IP and Technology Management in ICAR headquarters, New Delhi, where he plays a key role in monitoring, coordinating, and management of agricultural technologies and IPR activities across the ICAR institutes. So, we are truly honored to have such an eminent speaker with us today, sharing a valuable insight on IPR and technology management in agriculture, the topic of immense relevance to our today's innovation driven agricultural ecosystem. Over to you, sir. Please.
Thank you so much, Satrisa and team of Sarthi. And first of all, just I would like to congratulate to your team for organizing such a wonderful training. That is 30 days training, a national training program on Agri Sarthi. That is KRANTI, basically the knowledge revolution in agriculture and nurturing technology and innovation is the main theme of this program. So thank you, organizers. Before we start this topic, actually, I think you must. I think this group is involved. I mean, participants are from the academic background of this. Basically, the students of MSc, PhD, as I told, and other, academicians. So everybody, I think you must be knowing about the intellectual property rights and technology management. Basically, the intellectual property, as you know, whatever the intellect, created by our mind, that is the, intellect. And when your intellect is converted into a tangible form, it becomes property. So that is the intellectual property. And the rights over this intellectual asset or intellectual property is given under a certain law, that is the IPR. So basically, this is IPR, and the fundamental principle of IPR is the protection against unwanted competition. Protection against unwanted competition, and we have to, minimize that competition. So the future, nowadays we are, talking about the Amrit Kal, and country's progress for economic point of view. In that perspective, if we talk, the future of a country will be determined by its capacity to innovate. Every country's future, basically depends on the capacity to innovate and turn knowledge into wealth. And that is, the knowledge has evolved basically into a priceless asset. Knowledge is a priceless asset, and that may be exploited for financial gain in knowledge-based economy. So that is the basic concept of IPR. And whatever the knowledge you have created, you have given, you have your IP, and that must be protected. It has some commercial value. So it has, once the any asset has a commercial value, it means it must be protected. It must be protected. If it is not protected, if it is freely available to anybody in a ecosystem, then anybody can utilize it. And that when they are going to utilize it and they are earning some money from your IP, whatever you have developed, and that has been infringed by somebody, then you don't have any right. At that time, the requirement of IPR is necessary. Means you must have a certain right over your IP. When your IP is protected under certain law, then you can say that I have a right, I have a legal right over my IP. So that is basically IPR. So this is the basic, I think, just I would like to mention over here. And then this is intellectual, as I said, that when it is, intellect created in your mind, that is in intangible form. That is in intangible form. It has not become converted into the physical form. So when it is converted into the physical, that is in the tangible form, and that IP is basically not diminishing, not lost, not reduced, right? So that is the, in that case, it is the property, that is the intellectual property, when it does not diminish with use, when you are going to use, and there are certain rights are given under a certain law, certain statute. That is the role of state, and that protection is basically the legal protection. And your that IP has somebody's monopoly right. You have created, it means you are the owner, and you are the custodian of your IP, and you have the monopoly right. You want to utilize it by somebody, or you want to allow to utilize by somebody, or you don't want to allow, that is up to you, when it is protected under certain legal law. If it is not protected under certain legal law, it means you don't have any legal right over your IP. So that is basically IPR. When this IPR legal rights are conferred by the state, when we are talking about the definition, to the owner of an intellectual creation, you are the owner. That is in the original form you have created. And no, this is not, I mean, whatever IP you have created, when we will call it IP, when it is not existing in public domain, when it is not existing in public domain, then it will be protected under certain law. If it is already already the available, or somebody has developed, or it is already available and protected, your IP will not again be protected, because it has already been created by somebody. So it must not be existing in nature. in a public domain. So it may be manifested in the form of invention. It may be invention. It may be literary artistic work. It may be design of an article, symbol, distinguishable marks. So these kind of different kind of IPs are protected under different laws. There are certain laws are made by the by the statute, by the state, by the country. Each and every country have their own law for protecting these IPs under certain forms. So that's why I mean IPR is a general term. When we talk about IPS in general term covering the patent, copyright. When we are talking about patents, patent cover under the patent law, and then copyright law, then trademark, then industrial design, then geographical indications, as you know, all the layout design of integrated circuit, and then undisclosed, even undisclosed information, that is a trade secret. This is not under certain law, but it can be protected certain mechanism, certain that kind of mechanism is the no exclusive legislation exists, but the matter would be generally covered under the Contract Act in in a Contract Act, as you must be knowing, 1872. So, on a certain kind of agreement, we agree, and I agree, and you agree that okay, both I will not, you are saying that oh, I will not disclose your IP, and I have given certain trade secret, and that is basically called is the know-how. We can say the know-how also. Then and these are the different form. I mean the features of this IPR, as I indicated, that it must be a statutory rights, a certain statute, and a certain territorial in nature, like in Indian condition. It is for the in case of the patent, it is given for 20 years, and like in the varieties given for 15 years in case of the extent. I will explain in my coming slides. And then this is given for the monopoly right. Monopoly is given to the creator, to the innovator. You have created your IP. It means you are having the monopoly of that. You want to utilize it by somebody, that is up to you, or you don't want to give to somebody because you have already protected it under certain law. So you have the right to utilize it, right? And then I mean that you can exclude others from unauthorized use, as I explained. And then it is given for a certain period, that is the limited period for these IPs are protected for certain period. And these the even the future prospects also are there of your IP, and it require disclosure. When you are going to protect your IP, you have to disclose the information about formulation, how you develop that, but up to certain extent. You don't want that is your smartness, how you explain your IP which you have developed, how you develop that. I mean the methodology which that you have to disclose while you are going to protect, you are going to file for protection of your IP. So disclosure of information is also required, but up to certain extent only. I mean, you don't need to disclose each and every steps, every point. Only certain requirements are there. So that kind of requirements you have to fulfill for protection, taking protection over intellectual asset which you have created. And these are the different forms of intellectual assets. I mean, all these assets are not, we cannot get the IPR, but these are assets. One or the other way can be utilized. And most of these, assets are being protected in one or the other forms. Like new technologies, as you know, technologies can be protected as a patent or design, right? It can be it can be in the form of the product or the process. Then modified technology, adopted technology, product, as I mentioned. Then biological resources also, like you have developed certain varieties, certain hybrids, certain parental lines you have developed, certain breeding material. I mean, the advanced breeding lines as a new variety you can protect, or certain gene constructs, clones, cultural, or even modified microorganisms which are available in nature, that cannot be. I mean that is kind of a discovery, but the inventions can be protected. Then the publication in the form of copyright, This can be protected. Different kind of publications we generally create in our when you are writing your thesis, kind of research articles, bulletin, and these all are the can be protected as a copyright. I mean, certain sometimes these copyrights are taken by the journals, by the the publishers, where from where you are going to get contact for publishing your book or article. So they already take care of all these things. Then the data is the main source of creation of any IP. So data utilized for or contribution of the data in creation of IP, that is also an important asset for any researcher or the academician. And then the core competency, the professional services, kind of providing, you have certain experience, certain expertise in your field of expert area of your expertise, and you can provide consultancy. So that kind of the creation you have, that kind of experience you have, so that kind of competency that comes under the professional services, like contract research, consultancy, knowledge sharing, that is also kind of asset, right? Knowledge which you have gained that, and now you want to share or not, so that is up to you, but it is kind of asset. Then this is very important. I think this everybody know. I mean, when I think most of the students are from the agricultural background, this must be knowing that plant diversity interprets, as she mentioned in introduction, that yesterday I think you have some biodiversity related that lecture. And in that lecture, they have given certain kind of and what is biodiversity and all, So that is this here. I would like to mention that the approaches of balancing the rights between the creator, who the creator of the genetic resources. Creator means conserver. Conserver, who are the conserver? That is the farmer. Farmer are the creator and conserver of plant genetic resources, and the innovator, the breeder, who they are going to utilize that. They are going to utilize that, and they are also creator. I mean, breeders are also creator. So that's why in the breeding definition, the farmers are also breeder, in the PPBFRA law when we are talking. So these are the different international, the policies, how this paradigm shift, the germplasm exchange mechanism have been, introduced all over, globally when the globalization and privatization era, started. Then in the last 4 decades, we can say the germplasm exchange mechanism have rapidly changed during this period, and due to trends of globalization and privatization, the major paradigm shift, we can say, witnessed in the international policy environment in from heritage of mankind. From heritage of mankind, it means the things, the germplasm were available freely, available in the nature, in the in our agrobiodiversity. And when the certain, the international treaties formulated, when the India became the member country of, FAO, then the certain international policies formulated under these international policies, plant genetic resources, access and benefit sharing, I mean, utilization, access, and exchange of the plant genetic resources were regularized after introducing these international policies. So before making this international treaty on plant genetic resources, there was a free exchange of germplasm among all the countries, I mean, at the world level. When slowly this there are certain policies, that the kind of important policy, that was the Convention on Biological Diversity, it was introduced and enacted in 1993, where these all the member countries, I mean, India was also a country of this sovereign, and that all countries were free to take the sovereign right of the nations, and they can conserve and sustainably utilize their plant genetic resources. And even there was there is a provision of equitable benefit sharing. So this advocacy of CBD was to every sovereigner, to the country, different countries, that they can conserve their plant genetic resources, they can utilize plant genetic resources or genetic material, and after, utilizing, they can share the benefit sharing out of, utilization of genetic resources, and equitable benefit sharing. Equitable benefit sharing, how it is important? Because the farmers are providing, they are the creator of the plant genetic resources, so they must get some benefit. They must get some benefit. So these kind of provisions at the international policies were, highlighted, advocated. So after this, and it was the first legally binding institutional mechanism, and that was providing for conservation, sustainable use of all biological diversity, and with provisions of equitable sharing of benefit arising out of the use of biodiversity. And then this CVD reaffirms national authority to determine access to genetic resources. And genetic resources rest with the national governments and in the subject of national legislation. So in the subject of national legislations, each member countries, they have their own law. And then India also developed this BDA, Biological Diversity Act. Through this act only, we provide for conservation and sustainable utilization of plant genetic resources that regulates the access to all biological resources. And this place basically regular regarding access to germplasm, as I said, and raise the required level of negotiations. So conservation, this convention provided basically the framework of regulation for access to genetic resources and transfer of relevant technologies. So here the BDA basically gives the biennial and or this international treaty on plant genetic resources that facilitates the under the multilateral system utilization and access of genetic material, genetic resources under international this multinational system. Whereas this CVD advocates about the bilateral in the form of the bilateral access of plant genetic resources, and at the same time both the this treaty, international treaty ITPGR FA and the CVD, and it gives the regulates the and facilitate about the benefit sharing by the farmers, benefit sharing for the farmers who are the conserver, and they are the basic the creators for plant genetic resources, so they must get some benefit. So these kind of provisions were given by this CBD and ITPGR FA to the member or all member countries. So India adopted that, and India taken care of while developing this BDA. And BDA, after BDA, in the provision of this BDA, Nagoya Protocol also developed based on this Nagoya protocols. Recently, ABS guidelines, access and benefit sharing guidelines, have been developed by government of India, right? In recently in 2014, these access ABS guidelines have been developed, wherein these farmers' rights and this access and benefit sharing provisions have been taken care as per the BDA. And BDA is basically, regulates by the authority, that is the National Biodiversity Authority. And National Biodiversity Authority gives the provisions and it regulates, and this is the authority. And in case of this protection of plant variety and farmers' rights, PPFR Act 2001, why it came? Because because India being a member country of WTO, and WTO in the TRIPS agreement, trade related intellectual property rights agreement, there was a provision that it was mandatory for every country, every member country, that they have to develop for their own law for protection of plant varieties and breeders' rights and farmers' rights. That's why India adopted it, and India developed our own law that was the unique law in the world, that is the protection of plant varieties and farmers' rights, because we have protected farmers' rights as well here in this PPBFRA, and all these rights have been defined for farmers. So we have taken care farmers also. That's why it is very unique law. Okay. So this is, the plant diversity interface, and where, these are the relevant law. Now we talk as you heard about these laws, different laws, Seed Act 1966, which is very old act, and but this is not, you see, this is not IPR law. This is not IPR law, but it needs for taking IPR. This law is required for, it regulates the basically the quality seed production, distribution, right, and production of the quality seed for the sale and the related issues connected therewith. Because nowadays this the draft of this seed bill is also coming for, it has been up for stakeholders comments. So now many things are coming very shortly, and so this is very important law for regulating seed quality, right, quality seed production to available to the farmers. So that is important when we are talking about, when we are going to release a variety or to notify a variety, that seed act comes into picture, right? So this is very important when we are going to take IPR on any this kind of plant varieties, right? Then the Indian Patent Act, as you all know, this is this gives provisions for exclusive right to grant it an innovator. You are the innovator or their assignee. Innovator can assign his or her IP to somebody or some company or some that they can take care of that for a limited, and this is given for a limited period of time. In case of India, patent is given for 20 years for different kind of innovations. Product or process are protected under Patent Act, and then PPVFRA, it take care of about the farmers' rights, breeders' rights, and researchers' rights. So all three rights are well taken care under this law. And then there are provisions of the benefit sharing. I will explain in my coming slides. Then compensation of farmers, recognition and award to the farmers. Why we are taking care of the farmers? Because farmers are the conserver, and they are creator also. They are, they act as a breeder also. They create plant genetic resources, they create the varieties. So that's why they are, all kind of rights of the farmers are equally important to take care, right? So then the geographical indications. The geographical indications, as you know, the goods are created in particular geography, and it is protected in the name of particular region or this product or which represent to the particular geography, right? Then the Biological Diversity Act. Biological Diversity Act is also necessary when we are going to take any IPR. So it takes, as I already mentioned, conservation of biological resources to take care of all this, sustainable utilization of plant genetic resources, fair and equitable benefit sharing arising out of the knowledge. This biodiversity. Yeah. And then these are different kind of, the IPR, as I already mentioned, that patent, copyright, trademark, and all this, because these all, kind of protection of plant variety acts were basically taken with the provisions of this UPOV, because we are not a member of UPOV, but we have certainly taken some rules and regulations from UPOV for formulating our law, that is PPVFRA, right? So this is patent, legally monopoly right granted to an inventor, because when we are talking about the patent in a term of disclosure of invention, whatever you have invented. So in lieu of that, your invention, you have given the monopoly right by under this law, Indian Patent Act. So then, yeah. So but your product or the process must be a new. When your product is new, then it can be, and it must. There are certain criteria for protection of this taking patent over your inventions. It must have involved the inventive steps, non-obviousness, and it must have the commercial value. Industrial applicability, and the exclusive right is given to the inventor for making, selling, or using it, right? And these are the different, non-patentable subject matter in case of, our agricultural science. That is, the plants as a whole are not patentable. That's why the PPVFRA, we are taking care of all these, plant varieties, right? And then the animals in whole or the part of thereof microorganisms, they are not patentable, right? And then seeds, varieties. And these, the seeds and plants, all these kind of things and the seed varieties we are taking care of, because that is ultimately, usable for, farmers. So those kind of the provisions have been already been taken care in the PPBFRA, because this is the, we can say the patent law, the patent design law in India was the oldest law. At that time, it was not realized, right, the importance of the seed and varieties, and that's why it was, it was not, elaborated. And then the traditional knowledge also it not patentable, and methods of horticulture and agriculture are generally not patentable. Then the challenge is because we are using most of the, in most of the cases in the research in the agriculture science, we utilize the biological resources. When you are utilizing biological resources and you are generating, the knowledge or the research you are getting, or you are getting IP, then certainly there are certain requirement of BDA, where you have to take permission of National Biodiversity Authority for sharing any, knowledge based on the biological resources, right? Or it is, or your knowledge or your IP is going to utilize for, commercial utilization or kind of things. I mean, there are different these provisions in the BDA, biological diversity. So these are the kind of challenges we can say. Then after, when you are going to file a patent, or the, you're going to take a IP on your IPR on your IP, then you have to disclose the name and source of that material, right? So these are the kind of, then you have to say in certain cases deposition of microorganisms or the biological material is also required in national, repositories, right? Like in the case of the plant, that is NBPGR, NBAGR animals, and all, in the international level, there one lab is there in the Chandigarh. So all kind of, these requirements, provisions are there, and that compliances you have to take, before taking any IPR over the biological resources. So these are the different challenges. And then geographical indications, geographical origin of a particular your the biological material is also required. So these are, then the disclosure and filing of sequence, listing nucleotide, and different, the information, tedious information is required before, filing for IPR, for taking IPR on your, any IP which you have created based on the biological resources in agriculture. These are the different opportunities also. Like, there are certain startups, they can take patent, right? Startups are coming up very fast, and they are also, protecting their gen or their IP as a product or process, like in the patent. And then applicant is a small entity, can be as a, the applicant or the department. So and then applicant as a whole, as an institution. I mean, you are working, and through your team is working, and then whole institute can be an applicant for that, taking any IPR of your invention, right? And then this is basically in the theory behind this creation of this PPPFRA, because TRIPS agreement, there was an Article 27.3. It was a B is it was a requirement of this article under TRIPS, that every member country has to, protect their plant varieties, and they can develop under WTO, they can develop their own law for protection of plant varieties. So based on that only, we created, there was a condition that you can protect your plant variety as a patent, as in US patent, patent act is there, where the plant varieties are protected in certain other countries as well. But in India, there was no provision in the patent for protection of plant varieties. So then the member countries were free to protect their varieties. An effective sui generis system they can adopt as an effective sui generis system. We adopted this system, effective sui generis system, where we are protecting farmers' rights, breeders' rights, right, as well, and then researchers' rights also. So based on that, we developed this PPPFRA, and then or any combination thereof. So all this, the provisions were there. Based on this, India developed this PPPFRA. And the PPPFRA basically, it has statutory organs, that is authority and registry. So under registry, these are entered the varieties when you are getting the protection, right? And the authority regulates all these provisions. And this it recognized contribution of farmers in agro-biodiversity conservation, as I said. That's why the farmers' rights are, taken care. And then, PPVFR Act in 2001, it was, a rule were formulated first in 2003. And initially, first set of 12 crop notifications were there. And means 12 notification of crops means the guidelines, the dust guidelines, distinguished uniformity and stability guidelines were described for and established for these 12 crops initially in 2006. Now, they have developed more than dust guidelines, more than 200 species, 200 crop species. So now they are protecting the varieties from different 200 crop species, right? Then registration, first registration was started in 2007. And these are the basic objectives of the PPVFRA, because this gives the system for protection of plant varieties and rights of the farmers and breeders, as I mentioned. And it also helped in the, in respect of farmers, in respect of their contribution made at conservation and improving, making available plant genetic resources for development of new varieties, because farmers are, contributors for developing new varieties, material, they provide material. And the breeders to, stimulate investment for R&D and development new varieties in a public and private sector, as you know, that the breeders are developing in the private and public sector as well. And then this law provides for growth of seed industry to ensure the availability of high quality seed and planting material to the farmers, right? Seed industry are involved. And so the private people are also, depositing and taking protection over their varieties, and public sector also, right? So this is the, just, the process of filing for protection of varieties under PPVFRA. First, PPVFRA examine your application, then fee and seed you have to deposit, then complete application. If certain requirements are there, they will tell you, then complete application is deposited. And after deposition of that, they give they provide the dust testing and, at the different centers of the NARS, right? At universities or ICAR centers, then publish in the plant variety journal. If you want to, they will publish. If you have some, the opposition, if somebody say that no, this is my variety or this is my material, then you have to, you have to give justification and give the information. And before, registering that is kind of procedure is there. So when it is, this procedure is passed, the no opposition comes, then the issue of certificate of registration is done by PPPFR authority. And then and it would be, given under this, entry under this national register. And then annual renewal fee provisions are there, because it is given initially for certain period, then you have to renew that variety for extended period. Then compulsory licensing provisions are there. That is that when the one certain company or certain, licensee is not able to provide quality seed and timely and at the good rate, right? Timely and quality seed at the defined or the uh, appropriate rate, then there is a provision to give that right to somebody else, or the before 3 years. So that kind of provisions are compulsory licensing rights provisions are there. Then benefit sharing, as I mentioned, when you are developing a variety and you are using a parent or the material which is coming from the farmers, like land races or something, other kind of farmers varieties, then there are provisions for benefit sharing, right? So like suppose some material is coming from the folk variety, or as a parent you are utilizing, and then there are certain provisions of benefit sharing also. And then these are the different varieties are protected under this law, based on the different species like tree and vines. The whole protection, the total protection is given for 18 years from date of registration, right? It's 9 years initially and then extended up to 9 years. Other crops, 15 years date of registration in case of extant varieties. Extant variety is 15 years from date of notification of the varieties. So now the notification of your variety under Seed Act is required. That's why Seed Act is also very essentially required, because from that date only they will consider, right, for 15 years after notification, or VCK, I mean variety for common knowledge. After, if it is extended after 15 years, it will be called as the VCK, variety of common knowledge, right? So this is different criteria of testing of variety under this PPVFRA for protection of this. Only this criteria, when the variety fulfill or pass this criteria, then it would be able to protect it under certain this type of different kind of variety. Like if it is a material of kind of extent variety, if it is extent variety, they will test for two locations for one crop season. A new variety, if they are considering it as a new variety, then two locations, two crop season. I would explain in the coming slide that what is extent, what is new variety. And then farmer variety, as you know, and EDV, essentially derived variety, decided by authority in case-to-case basis. What these varieties, important features of this, because these researchers' rights are well taken care. And for conducting experiment, there is a free, I mean, the researchers can take material for conducting research and developing new varieties. So there is no this one, any restriction, but authorization of breeder for registered variety is required when the researcher or the breeder is going to utilize that variety for commercial production. Means, for if repeatedly going to use as a parent for example, in case of hybrids, if you are going to develop a hybrid, so every time you need parental line, then in that case you have to take permission of the breeder. So this kind of then the extent variety, as I mentioned, the varieties which is protected for 15 years from the that is date from the date of notification of the farmer's variety. The essential derived variety, authorization of repeated use. Essentially derived variety is the variety which is coming from the initial source of the variety, right? And then safeguard practice of farmers. Farmers can resow, exchange their seed. I mean, the variety which they are, propagating or developing their farm, and they can, sow, resow, I mean, they are free to use that. So these kind of provisions for farmers, that's why the farmers' rights are taken care, so that, there should not be any foundation over the, farmers utilizing that variety. So not sell, but they cannot sell branded seed. Farmer cannot sell branded seed, but they can, exchange their seed within their community, but not branded seed. And benefit sharing provisions are there. Compulsory licensing, as I mentioned. So this is a new variety. When we call this new variety, when you develop that variety and the seed of that variety has not been sold within 1 year, right? Within 1 year, if it is not, it is not giving to the market, or it has not been commercialized, then it will be considered as a new variety. Otherwise it will come under the extinct variety. So outside India, tree wise, I mean, there are provisions for 6 years. In any other cases, 4 years distinct, but that must be distinct, uniform and stable. Distinct means it should be distinct for a character for which it has been bred, it has been developed, right? In that, character should be distinct from all other varieties. And then it should be uniform. Your character should be uniformly stable. It should not be, segregated in generation after generation. So it must be stable, right? So then it will qualify this as a, the new variety. And external variety is already notified, so this is stable. It is assumed that it is stable because it is already notified. Then farmers variety also can be considered as extant variety, and variety of common knowledge after 15 years. I mean, this is old kind of variety. Then essentially predominantly derived from such initial source of variety. I mean, variety which is developed from initial source of parent, right? And that confirms all the traits of this our old parent, but it has new character, one character for which you have bred it, and that except for differences which result from the act of derivation, means that particular trait for which you have developed it, that must be distinguished, that must be different from the, otherwise all character from the old variety must be there. So this is the initial, that is the old variety which is used as a parent, or we can say the source material, right, as an initial variety. in the expression of essential character. So all essential character, the variety which we have developed, which is coming from the initial source of material, initial source of variety, but which is having, you have cumulated all the essential characteristics except one additional character for which you have bred it. So that is the essentially derived variety. It must be, as a student, you must be knowing this. Then the farmers traditionally cultivated involved variety, farmers variety. This is also, as you know, the certain folk variety, cultivated variety of the plant that was developed and grown exchange informally among farmers. So, in the folk varieties, we say folk varieties, and then land races, you must be knowing those kind of things. So they develop, they give the source for these farmers varieties. And then researchers' rights are also, as I mentioned, they can conduct experiment or the research for developing new varieties, use initial source of variety, and provided the authorization of breeder is required for registered variety, where the repeated use of varieties as a parental line. Suppose for the development of development of hybrid. So those parents are being utilized for development of hybrid every time, then there is a need because that is going to utilize commercially also. So that is, the authorization of registered breeder is required for those parents. And yeah. So certain, privileges for the farmers' rights, they can save, so as I mentioned, the new varieties and extant variety of farmers can also be registered, and rights of the community, any person or group of, the community as a whole, community or local community can claim on attributable to the contribution of the people of that place or the local community in the evolving or the developing of new variety for developing of variety for purpose of staking claim on behalf of such village or local community. So those kind of provisions are there. And farmers who has bred or new variety can register his new is a variety new as a new variety. Farmers were a farming community registered variety must be made available at reasonable price and reasonable quantity. So this kind of provisions are also there in benefit of farmers. And then farmers are also, they are having certain kind of relaxation from the innocent infringement to the farmers. They have innocently they have infringed something, then they are also in those certain protections are there. The farmers are exempted from all fees except annual fees. So they very nominal fee they require to deposit for renewal of their varieties. And then farming community has right to be rewarded and recognized. There is a provision for giving, certain kind of awards to the farmers, because farmers are the contributor for developing new varieties. So Gene Savior Award kind of things, they save or they conserve the plant genetic resources for development of that is being utilized for development of new varieties. So those kind of, the benefits are also given to the farmers. Those kind of provisions are there. GI, as I mentioned, that these are, an indication which identify particular good as a originating or the manufactured from a particular region where a given quality, reputation, or other characteristic express, as such goods in is the basically it is essentially, attributable to its geographical region, particular geographical region it expressed. And then it is giving the collective IP of entire community or the society or organization of geographical region, because the GI is basically given for the collective, organization. I mean the community or society or organization, not individually. It is not given or protected. The goods of created by individual. No, so it must be given to the society, and then but it essentially governs a collective rather than individual, as I mentioned, individual right that represent a specific link between goods and the place of their production, right? So different classes. These are the different classes where these agriculture goods are protected. Class 1, 30, and in total 34 classes are there. So out of these 34 classes, these different classes, gives protection for GI in case of agriculture goods. So different kind of agriculture goods are there. These are certain examples in a certain area, in the states, right? And when we talk about the portfolio of agriculture good registered as a GI in India, then we can say this more than, that more than 200 GI have been protected. It was the data of between 2014 2024, around 200 GIs were, protected. So this was the best period for protecting GI agricultural goods, for GI for agricultural goods. This is BDA, as I mentioned. As I already mentioned about this Biological Diversity Act, because in this act, as I mentioned, they regulate access to biological resources and associated information. So non-Indians, they cannot use. They have to take permission of NBA, National Biodiversity Authority. Indians intimate to state. I mean, this law has been, amended in recently in 2023. Basically, in the section 4, which has been modified, that is the no person or entity shall share or transfer any result of the research on any biological resource occurring in or obtained or accessed from India or traditional knowledge associated thereto for monetary consideration or otherwise to a person or the body corporate referred to subsection 2 and section 3 without the prior approval of NBA, except the codified traditional knowledge, which is only for Indians, must be there. So for research results, for further research, registration with NBA is required. If you are going to utilize the research results for further research, then NBA. But it is, I mean, there are certain exemptions are there for collaborative research programs, and for commercial utilization and obtaining IPR. And if we are going to utilize the resources for this and taking IPR and going to utilize for commercial purpose, then inside or outside India, then you have to take permission of National Biodiversity Authority. So there are certain, provisions are there. Certain modifications have been done recently in an amended law in 2023. And this 2022 law was, amended. And in this law, they have defined access also they have defined. Then the codified traditional knowledge they have added, and then the derivatives also they have defined, means naturally occurring biochemical compound or the metabolism of the biological resources, even if it does not contain functional unit of heredity. So that kind of, the compounds comes under the derivatives. Then they have defined folk varieties also they have added, means a cultivated variety of plant that was developed or grown and exchanged informally among farmers. So that is folk varieties they have considered it. And then the land races, earlier it was not there, they have not defined. Then land races also they have included, means the primitive cultivars that was grown by ancient farmers and their successor. So those kind of things have been added. And this basically the major changes have been done in few, sections. And then for the collaborative research programs, international collaborative research programs, there are certain, guidelines for, in our case, that is, the guidelines issued by DARE, Department of Agriculture Research and Education for Agriculture Research, is the nodal, agency, nodal department, which regulate all these, collaborative research guidelines. So your foreign collaborative research program, if you are going to, make any kind of agreement for taking collaborative research with the international agencies like universities, public sector universities, then you have to follow these guidelines. And then guidelines of MOEF, that is for MOEF notification 2006 for exchange of the material, biological material. So those kind of certain guidelines you have to follow with these conditions. This is IP management. If we talk about IP protection and initiatives, IP management at ICAR, when this culture was introduced before independence, patent applications in agriculture we talk, and then it was filed by the Cotton, Mumbai, and Jute Kolkata when before independence. These two institutes they filed the patent and design at that time. Patent and design act was there. So after after independence, first patent application was filed by IRI. IRI in the Patent and Design Act as a as a design of plow mold, desi plow mold. So that was the design was filed as a patent, right? This was the first patent, we can say, first patent application in IRI after independence in agriculture. During this period, 1950 to 1995, 74 patent applications were filed by 10 ICR institutes initially. And then 96 to 2000, 2000 IPR cell at ICR headquarters established, and that implementation of Johor Committee guidelines that basically gives regulations for the training, consultancy, contract research, contract service. So your competency and expertise, as I mentioned earlier. So that kind of IP, which is not given for certain protection, but there are provisions for giving the share of intellectual as an intellectual fee. I mean, whatever intellect you are giving to certain agency or certain client, then there are certain provisions in these guidelines. The ICR made certain guidelines to give the benefit to the the scientists who are the giving this intellectual this input in a certain based on their expertise to the outside client. So those kind of provisions were there. And 2006, the preparation of IPR and this implementation of ICR IPR guidelines were made. These were recently revised in 2018. These guidelines, based on these guidelines, our whole intellectual property management and technology transfer and commercialization are being undertaken in all ICR institutes. This provision that these guidelines we coordinate from here, we monitor based on these guidelines the whole these activities of IPMTM, intellectual property and technology management in ICAR system. And based on these guidelines, certain universities also they develop their own guidelines based on the background information or the provisions in harmony of these guidelines. They also developed certain universities, agriculture state agriculture universities, and this is the basic scheme of the intellectual IPTM scheme, that is the National Agriculture Innovation Fund scheme, was launched in 2012, and before that in the 11th plan it was there, and the IPR culture was introduced, and then then this full-fledged scheme was formulated, wherein this innovation fund being run in this the three-tier system. Three-tier system means IPTM ICR headquarter from top down to top-down approach from IPTM unit to zonal centers. Zonal centers are ZTMU called. And then at the institute level, we have institute technology management units in each and every institute. They are looking after all kind of activities of IPR and technology management. And under this, based on these guidelines, provisions of these guidelines, they protect our scientists' innovations and the transfer the technology and commercialize technology based on the provisions of these guidelines. And then we have the incubation funds. We have startups. Our institutes are developing startups, and they are having the 50 incubation centers in ICR, where we provide the technical backstopping to create the startup entrepreneurs based on the ICR's technology or their own technologies. And our institutes facilitate, these incubation centers facilitate for developing the entrepreneurs and startups to establish their business enterprises, right? And then this new IPR policy government launched in 2016. Based on that, we harmonized and all these provisions, and then we revised in these guidelines in 2018. ICR revised these guidelines in harmony of the provisions and the rules and regulations of the national IPR policy. And then we have Agri Innovate India Limited, that is the DARE's separate entity for commercialization of technologies. Because being a student of agriculture, you must be knowing what is the IP mechanism in ICR or in the NARS. So this is the established the system where this a whole IP management and technology transfer, the policy based on these policies these activities are being undertaken by different institutes, and where our scientists are developing different technologies, innovations are coming, and they are being protected under different laws. And those technologies, once, I mean, you see, when you have developed your technology, you have protected your technology under certain law, IP as a IP. But if this IP is not going to commercialize, it doesn't, I mean, there is no meaning of that kind of IP. It must be commercialized also. I mean, if you have developed that IP and you have protected also, so you have taken IPR, and now that IPR must be commercialized. So that must be our, thinking. I mean, we always, give certain this kind of, the the words to our scientific fraternity, that when you have developed your IP, it should not be limited up to the documents. It should come out and it should commercialize also after protection, right? So first you have to take protection. So this is the IPR portfolio of ICR. We have, submitted more than 1600 plant varieties, 1650, and patents 1851. These were, the applications were filed. So, and the protection also on plant variety, in case of plant varieties, around 1200, more than 1200 we have already taken. And then patents like 1100 something, and then copyright, design, and all, so and so on. And this is the basic, the patent filing trend at ICR. And this was the basic design. It was, the first time protected by IRI. That was the first patent of in agriculture. So this was the, basic mold design. And this is, the 5 yearly the portfolio of patent filing train in ICR. And then technology licensing, we have done a significant licensing of technologies we have developed. More than 6,000 licensing agreement have been signed for different kind of technologies that are generated in ICR, and for 1,800 plus technologies. And then 2,800 plus public and private organizations, partnerships have been done, and more than 85 ICR institutes are actively, contributing these kind of technologies and licensing agreements spread all over 28 states. And this is the, zone wise status. Southern zone, northern zone, and this western zone are having, the significant licensing. And then and then these are the different kind of industry-wise technology classification. When we are talking about technology commercialization, then highest actually seed and planting material contribute in the commercialization of technology, and then food processing and post-harvest related technologies, and then followed by this farm machinery and tools kind of technologies are giving, significant contribution in commercialization of technologies. And these are different our divisions, where all, related institutes, they are contributing in the licensing technology, commercializing, developing technologies, institute-wise, right? So this horticulture, and then the crop science, of course, these are the big number of licensing, and then crop science, fisheries also good number of, then agriculture engineering. These are the different, incubators, agribusiness incubators in the different subject matter divisions. In agriculture engineering, we have 5 agribusiness incubation centers, education to agricultural science, like in crop science, and all these, 50 incubation centers are there. And we have developed more than 2,700, entrepreneurs incubatees supported by these centers, developed by these centers, and entrepreneurs started initiated their business. Around 900, more than 900 startups, they have started their business also. By developing, by facilitating or supporting by these our institute, 50 institutes, the different programs we have done. And this is the impact. Actually, if we say in the whole ecosystem in agriculture, startup system, ecosystem in agriculture, so this impact, it was, realized that more than 12,000 employment have been generated. And if we talk about the farmers benefited, more than 40 lakhs of farmers have been benefited. And this is the progress impact of this incubation startup ecosystem in agriculture. Because this scheme is also being run under the ministry, by one ICR centers under ABIC, and Raftar centers under ministry, right? These are the different crop notified. This guidelines, as I mentioned, more than six, and this is just IP under our IP portfolio. Number of applications received at PPFR till October. This data was taken from and these are the different situation. Portfolio of these farmers varieties and extent variety. And highest number is the farmers variety, more than 12,000. These are different kind of crops where this number of total 20,000, more than 20,000 crop varieties have been submitted for protection under PPBFRA. And this is more than 10,000 have been already protected. 10,000, more than 10,000 varieties have been protected in different categories, right? And of course, extent varieties are high. And then first is the farmers varieties are having highest number, and then extent, and then right. And this is the situation of public, private, and farmers. Farmers have contributed a lot number of varieties, more than 50% to be issued. And this is a different crop species where a number of varieties have been registered. Cereals have highest number, then fiber crops, then vegetables, and then fiber crops. Total more than 10,000. Yeah, this registered variety of ICAR and different, in the ICR, if we talk, more than this 1,600 varieties, and maximum number, if we talk about, that is the rice, maize, rice followed by maize, followed by, and this wheat. So these are the different, the scenario of plant variety protected under PPBFRA submission, and this is the registered varieties. Basically, earlier that was the submitted variety in earlier slide, previous slide, and this is this is finally registered scenario, right? And one variety example I have taken here, the technology commercialization impact of a single variety, you see, and that is more than 2,000 seed companies have taken this variety, wheat variety SD3086. It was licensed. So this is the impact of, coverage of, and then the second example is the rice Pusa Basmati 1509. And this was also, licensed to more than 43, companies. And it has covered a huge area, and it is contributing a lot in revenue of country, right? And so this is the points you can take away. That is the IPR, as I mentioned, is the legal framework for protecting the rights, and then the rapid advancement in the field of frontier science. If we are talking nowadays in the frontier science in agriculture, especially, which gives for emergence of the new legal and technological regime that regulate the access of plant genetic material. And this international, as you know, the international policies, they in this regime, they give they advocate in the protection mechanism for innovation, and they give the impact on access and transfer and exchange of biological material, which is basically required for furthering research and development activities in agriculture, because this is the major, portfolio is the plant genetic resources. And then IPR allows investors to make a long-term investment in innovation. When we are talking about Atmanirbhar Bharat, then the IPR play an important role while we are developing the technologies, and the technologies are appropriately protected under appropriate laws. So that is very important under, when we are talking about Atmanirbhar Bharat, because we have to be, Atmanirbhar by 2047. So those, this kind of, the important IPR steps, IPR mechanism, everybody must know, because you are being a student of in this area. So you must knowing this, what is happening, and how much is important IPR. Thank you. Thank you so much for patience listening. Thank you. If you have any question, please you can ask.
We express our deep sense of gratitude to our esteemed guest, Dr. Shiv Datt, sir. His vast experience and scholarly insights have greatly motivated and enlightened all the participants. Sir, thank you for this power-packed session. We all now be moving to on the query and interaction session. Instruction to the participants. Those who have questions are kindly requested to use the raise hand feature. When invited, please unmute yourself, turn on your camera, briefly introduce yourself, and ask your query. Participants may also post their questions in the chat box. Sir?
Yeah.
So, one
Yeah. Can you
student is there.
read any question? Yeah. Please.
So, PhD scholar is there, Rajani
Yeah.
Balan. Her question is, how can farmer and young agri entrepreneur practically benefit from the IPR protection, and which type of IPR are most relevant to us? With addition to this, she also asked, what are the common mistakes researchers and startups make while filing IPR in agriculture, and how can they are avoided?
Oh, okay. Thank you. Thank you. So I think this is a very good question, very pertinent question over here. When, as a farmer or as a entrepreneur, when we are talking as a farmer and entrepreneur, they protect their innovations as a first innovation, that is the when we expect, that is the plant varieties. So they can protect their varieties under PPBFRA, that is Protection of Plant Variety and Farmers' Rights Act, number one. And then when they create the innovations, they can protect their innovation as a design, based on their product or process, right? If the product related to the design or the patent, it can be protected under patent or design. When you are, see, the protection of any IP or any innovation, when it is required, it is required when you are going to commercialize it, when there is a value, it has some commercial value. If it is going to commercialize in market, if it is going to open in market, then before that you have to protect it. You have to protect it, and see, you must have certain legal right. Otherwise you will lose that your innovation. So somebody can infringe that. So that for just to stop that, you have to protect it under certain law. So that is required. And then second question was, what was the second? Can you repeat, please?
Yes, sir.
Yeah.
What are the common mistakes researchers and startups make while filing
Oh,
the IPR in agriculture,
yeah. So
and
the,
how
the
they can
common
avoid
mistake,
it?
yeah. So the common mistake basically the people do is they disclose unwanted information as well. So you disclose all kind of methods, whatever you have developed right from beginning to end. But that is not required. You are required to disclose only that information while filing your IP to get protection. That only required information means the methodology only. That somebody cannot take and as well, because that your information will go in public domain also. So no, so somebody cannot take the steps where whatever the steps you have disclosed it, so that cannot develop the as such your product or as such your innovation. So that kind of the precaution must be taken care of by every startup or the student researcher, or whenever you are going to file a patent, suppose, and you have developed the methodology in your research program, and now you have developed innovation, you have the product or process, right? Now you have to disclose. So disclosure of information must be a certain limit. It must be a certain limit so that somebody cannot infringe it as such. So that kind of the precautions must be taken care of by all the researchers. That is my advice. Okay. And because it is normally happen with the people when as a scientist, as a researcher, you are this researcher, you have created something. Now you want to disclose each and every point of your invention, of your inventive steps. So that should not be there. You have to very precise. You have to be very precise, very limited, the things you have to disclose. But the information must go like they should know, the examiner must know that, okay, this, this method they have applied, and this is the new product, and this is, this product has never been developed by somebody. Okay. So for that, you must read prior art search also. Before starting, before inventing anything, you must search whether the prior work has been done for this research or not, right? So that kind of information must also be there. When you are going to plan a research, because it is already been protected. If suppose your product comes or your process comes after completion of your research, and that has already been protected, that it doesn't, that then it doesn't, any sense. It doesn't make any sense to protect it, because that will not be protected. Because when you are going to file your innovation for protection or process or product, the examiner will, in the patent office, they will also search whether this this invention has already been protected or not, right? So if it is already been protected by somebody, you will not get any protection on your process or product. So that is, those kind of, the basic principles must be known everywhere, right? Yeah.
Thank you, sir. So, next question from Ritesh Kumar. He is MSc GPB department.
Hmm.
Chaudhary Sarvan Kumar, Himachal Pradesh, Krishi Vishwavidyalaya, Palampur. His question
Yeah.
is, if
Hmm.
there was uh, Patent and Biodiversity Conservation Act, UPOV, was there, why PPVFRA was needed for the breeder IPR protection?
No, breeder, that PDA basically is not giving you a protection. That is not a legal right, but not a legal act, right? Legal law. This legal law means that is not giving you IPR law, IPR protection. That is not going to give you IPR protection. But that is required, BDA is required for taking care of the conservation of biological resources, because all whatever kind of biological resources, genetic resources we are taking from nature, and that is the custodian. Who is custodian? That comes under the BDA. That is the that comes under the BDA, Biological Diversity Act, because that is for the conservation and sustainable utilization of biological resources and benefit sharing accrued out of it. Means who is providing, who is creator, who is creator is giving that material. So that kind of provisions for benefit sharing is also given by that law. But now the question is, whatever the creation, whatever the variety you are going to create, that must be protected under certain law, that must be protected under certain legal law, legal right. You must have legal right. A legal right can only be taken from PPB FRA. So PPB FRA, like patent, PPB FRA gives the protection for plant varieties for certain period, but that resources is coming out from the our biodiversity, and that biodiversity is custodian is that under in that NBA, that is under BDA. So those kind of provisions are being taken care under BDA. So both requirement of BDA and PPVFRA is required, right? Because benefit sharing is there. So benefit, if the benefit sharing is there, who is provider? You don't know. You have taken that material and the farmers have generated that material, but the ultimately you are going to benefit after developing a variety, but farmer is not going to benefit. So farmers, the rights provision has been addressed in the PPVFRA as well and the BDA also, right? So BDA take care of the conservation and the sustainable utilization and benefit sharing. So these three things are taken care in the BDA, right? So both laws are important. Yeah.
Thank you, sir. Extended to your answer, one question from Umed, MSc scholar. She is from Banaras Hindu University.
Hmm.
He asked that farmers are unaware and being exploited by the money makers and some companies. How, as a student, we can help them?
Yeah, I mean, you as a student, whenever you are getting, the chance for, giving, sharing knowledge, you must first you must know the about these laws and this PPVFRA and farmers' rights and right and what are the provisions of BDA. So as a as a knowledge sharer, I mean, you can advocate them, you can tell them, these are their provisions, they are their rights. You have to tell them right, and then whenever you get chance to to help them, you must facilitate them, to must facilitate them, and before that you must be aware about these things, about our laws, our the appropriate laws of protecting their material, right, filing, even for filing their innovations, like for farmers innovations, our you one that sanstha is NIF is working, and they always help to get protection for farmers innovation under certain law, as a patent or as a design. They help to protect them, right? Our in our kiwi case, they also facilitate for getting protection of farmers varieties in PPVFRA. They help them to file their varieties. As scientists, our scientists also, our university scientists also, they help them to file the local community of the farmers varieties to the PPVFRA. So those kind of the knowledge, your knowledge can help to the farmers to get protection over their varieties, over their innovations. So that kind of help can be provided. Yeah.
Thank you, sir. Uh, I would like to tell all the participants that it is the golden opportunity to grab your knowledge and get more information about IPR.
And one thing, I think every student, they must, when you are, we are a student of agriculture, and everybody should read these, laws. When, whatever you are generating, you are, writing thesis, you are writing papers, you are generating some, you have developed some innovations. You must also read these, laws. This knowledge is always better for every creation. So I mean, under which law, under which law our kind of IP can be protected. So those kind of knowledge must be gathered by everyone, by every student. Yeah, please.
Sir, now one participant is there, Krishna Kumar Raghuvanshi. Kindly unmute yourself
Yeah.
and ask your question.
Good evening, sir. Myself, Krishna Raghuvanshi. I'm from Uttar Pradesh.
Yeah.
My question is that the difference between a patent and plant variety protection (PVP).
Mhm. Yeah, you see, the PVP plant, this patent does not give protection for plants, right? As I mentioned already, in section 3J, the plants, varieties, and seeds are excluded for protection, right? So there was no provision of protecting varieties, seeds, and these plants, right? Then that's why, I mean, as I mentioned in my talk also, then India does not have that kind of protection, legal protection in the patent. Then after this, the India being member of WTO, and there was agreement, that was the TRIPS agreement, and the TRIPS agreement, there was a requirement of every member country, that member country, they can develop their own law, they can develop their own law to protect their varieties. Okay. Then based on the provisions of their, and then UPOP's provisions, and because UPOP member, we are not a UPOP member, but we are member of WTO. Then WTO, they members decided certain, under certain agreement, that every member country can develop their own law for protecting plant varieties, right? Based on that information, then India developed this PPVFRA, and as a sui generis system. Sui generis system means they are taking their provisions, and based on our situation, our Indian condition, farmers condition, we modified that. With certain provisions, we modified that. So collectively developed this law PPBFRA, which fulfill the all criteria, all provisions, all rights of the farmers as well. That's why, I mean, we are taking care all these, varieties, seeds of, protecting these varieties, seeds in this PPBFRA. Yeah.
And sir, the second one is ki, sir, what are the criteria for a plant variety to
Hmm.
register under PBP system?
Criteria is the dust guidelines. Criteria is for every crop, there is a dust guideline. Dust is the distinguished uniformity and stability test. So there is a provision for each and every crop. They have developed certain criteria that is called dust guideline. Based on dust guideline, your material, your variety will be tested. Okay, at under different situation. Okay, and at defined centers, they have network centers, and you have to for filing there is a requirement for you have to deposit seed also. So seed quantity, certain defined quantity of seed you have to deposit to the PPFRA. They will send your seed to different centers. They will test it. If your variety fulfill the criteria of DUS, then they will consider it as a either new variety. If it is new, if it is really new, I mean that seed of the new developed variety you have not given in market before 1 year. Okay, so then it will be considered as new. Otherwise, they will take it as a extant varieties. Extant varieties as a after, I mean, some old varieties also, I mean, before, I mean, that has not passed the 15 more than 15 years of notification, or farmers varieties also, they can be considered as extant variety. So there are different varieties, different kind of varieties are there. They have classified it. Okay, either or EDV also there, essentially derived variety criteria is also there. So the different class of varieties are there. If your material is fulfilling that kind of class, it will be considered automatically in that particular class and will be protected. Yeah.
The last one is, sir, is there any role and impact of GI in rural development?
Sure. Why not? Because rural development, yeah, in the local community, like if I would say the example of your Kala Namak
Yes.
variety of Uttar
Yes.
Pradesh. So that is that variety got the this one GI. GI,
Yes.
this is protected under GI. In a particular, geography, it
Mhm.
normally it grown in that area. So and that particular quality, fragrance, and that color or that, so that express in that particular geography, so that is designated for a particular region. If that variety is being asked for export, if demand is coming in a market for export, okay, and if demand is coming for export, it means that variety, production of that variety is required in that region. So who will produce that? Only farmers will produce. Farmers of that region will produce, and they will give me the required quantity for export, right? I mean, this is just example. And the farmers, if the farmers are getting good price of that material, that whatever the variety they have grown, that definitely the rural, the economy of a particular rural region will be enhanced. So that is the contribution actually. Those kind of, they ultimately it will help in the development of rural economy. Yeah.
And sir, if you permit, one last question, sir.
Yeah, yeah. बताइए, please.
Uh, sir, how we define the term biopiracy?
Hmm?
How we,
Biopiracy.
yes, sir, biopiracy, how we define the term
Bio, yeah,
biopiracy?
yeah. Biopiracy, you see, biopiracy just you have taken a material that, your plant genetic material you have taken from certain area, and you are utilizing that material for, commercial purpose also. And without the, information to the state biodiversity board, or local, the biodiversity board, this management committee, one local biodiversity management committee is also there, and that you have taken that material, you have stolen that material, and you are exploiting that material, right? And you are getting benefit out of that material. and you have not taken any permission or any information. So that kind of things are comes under the biopiracy. So I mean, in the simple language, if we can say, yeah.
Thank you, sir. Thank you, sir, for your valuable time.
Thank you.
Thank you, sir. Thank you, Krishna. One message is from Kritika Sharma. She is a final year student from
Yeah.
CCA SHAU Hisar.
Hmm.
She dropped a message that, respected sir, thank you so much for the wonderful lecture. And her question is an undergraduate student, we have written articles and review papers, but for higher studies, we have to write our thesis and research papers. Please guide on that. In addition, also guide us that is there any entrepreneurial opportunity available in IPR and patents?
Yeah, first, I mean, just I will answer the last question first. And that is, when we talk about the opportunities of getting, in this field by the graduate students, and I would say for they may, develop their skill for, the student as a student entrepreneurs. As a student entrepreneurs, I mean, you have certain, idea, you have suppose certain idea, or you have some creation, right? And you can contact to our these incubation centers, business agri business incubation centers, right? And they can go there, they can discuss their ideas, right? And we have this idea and we want to establish as a certain startup, or as a entrepreneurs. Initially as an entrepreneur we can say, startup तो थोड़ा सा भाषा बड़ा हो जाता है, because that is they should have a turnover of more than 100 crore. So that is not. So a small business, small, we can say the small business, you can start from a small business, right? And you have a certain idea, you have a a creation, you have created something, and you have innovation, you have product or process, right? So by that one way, by that you can start. Another thing is, yeah, you can take innovation from the university or the research institutions, right? And they have their the product or the this one technologies. So based on that technologies, you can you can get support from agribusiness incubation centers, which we have already established in our NAR system. They will give you guidance for establishing a small entrepreneur, a small business, right? Those kind of things you can start, like. And another thing, another point, that was the publication, regarding publication. Yeah, you can write article, you can write paper. I mean, when you are you have completed MSc or PhD thesis, certainly you write, you all people write research article from your thesis, MSc thesis, PhD thesis. So then, I mean, these articles are protected under as a copyright also, because if you are, publishing your research article in a certain journal, so journal is already, they are aware and they take care of, right, that is the copyright. So they have already taken copyright, right? So in that way also, and you are going to publish a book separately, you can get also copyright through publisher also, or you can get. So I mean, those, I mean, there are n number of opportunities for getting IPR on your creations or your innovations, right? So in that way, I think UG students can also get help from our established centers, and they should discuss with your teachers also. I mean, teachers, scientists, faculty, they can help. I mean, they can take help from them. And even student hackathon, they can join the hackathon programs, right? Student hackathon programs, and generally our institutes or universities, they conduct. So they must participate in that. They can show their idea, their creations. They can participate in that. So in that way, they can get help, and they can be a very good, small entrepreneurs, or even at after some time at large, startups also, right? Yeah.
Thank you, sir. I think this information, not only UG students, all the participants it will help all the participants. Next, the other participant is there. She want to ask a question. Mariam, kindly unmute yourself and ask the question.
Please
Mariam?
unmute yourself.
Yes. Hello, Dr. Shiv. Datt. Do you know
Oh,
me?
yes, Mariam. Good evening, good evening.
I have
Very
been
nice.
hearing your
Very nice to
lecture.
see you. Very nice to see you. Yeah, please tell.
Yes, yes,
Yeah.
sir. So I also joined among the students.
Okay, that's fine, that's fine.
Actually, so interesting their topic. So I just joined. There is my one question. So doubt is there. Actually, farmers plant or farmers variety not yet identify the species or botanical variety, so to say. But they have been growing for so many decades from their forefather, growing and conserving. It is in Manipur. So,
Yeah.
what steps to be taken up for identifying or naming the species or botanical variety, so to say, or cultivar, so to say? And another question is there any financial assistance from ICR for the farmers? See, farmers are poor and they are conserving this crop, this plant in a very more than 200, 300 hectares like that. So acres, I think. So
Yeah.
they are poor. So and then for registration and all, nothing has been done. So what steps to be done and what I can assist as a this one, agriculture.
Yeah. Yeah. Which crop actually, Mariam?
Actually, this is the onion species,
Okay.
or onion
Onions.
species, a local
Yeah.
onion like a spring onion type.
Okay. Now I got your point. Actually, these varieties as a folk variety or land races,
Yes.
basically the farmers folk varieties, they are, developing, they are exchanging, growing among themselves, right?
Mm.
So that kind of, the varieties can be registered, yes, as a farmer variety,
Mm.
Even our KVKs, I don't know in your case that KVK is aware about that or not, but our KVKs are also facilitating to file farmers variety to protect under PPBFRA. And for that, there is a project, there is a separate project also from PPBFRA. These people
Mm.
give certain kind of funding for certain centers to get help to give help to the farmers and to help them to facilitate them to file their varieties to protect under PPVFRA. So that kind of help I think you can get. Otherwise, that help you can get from ICAR center also. ICAR scientists, they are aware about that. They help to local farmers to protect their varieties as a farmer variety under PPVFRA. And
As a CAU, or what can
that you can, that Manipur Center or that Barapani Center also you can contact. I don't know, Manipur Center somebody is taking care of this aspect or not, but at Barapani you can find out. At Barapani, no, these people they can help you. I think they will help. Otherwise, I will tell you who is there
yeah,
to.
I have to discuss with you. So,
And another thing. One office is also there in Guwahati from PPVFRA, this authority's office is also there. So you can search out that contact number of these people, and you can discuss with these people, and they will certainly they will help because that is for Northeast region. So they will help to register the as a farmer, very
oh. Sir,
certainly.
actually, some years back, there is some prize or some assistance is there from NPPGR. So
Uh-huh.
they have applied through me, and we assist with the one scientist from IRI, but they didn't get anything. So some
Yeah.
prize is there.
That actually first they should register this variety to the PPPFRA.
Yes.
Your variety, that variety, farmers variety must be stable. That should
Mm.
fulfill that criteria of DUS, and they will tell. That office will definitely assist you in that in this regard. And then that material, if they have registered some material, they have given some variety to the PPFRA. Certainly, they will consider their applications for some awards and all because that must be, as a contributor in conservation of genetic resources. They must be registered like that. So in that way, I mean, just you can contact to this office, no? PPBI
Go
office is there in Guwahati.
Guwahati.
Yeah.
Acha. Do you have a number and all, sir?
I'll provide. No issue.
Yeah, you please help me. And then for this identification for naming and all, me and another from this one IRI, we were doing, but so far not yet. That kind is we have to submit in the some article journal and we have to publish or something like that, or how to do that process.
No, that process actually, you have to submit that material. They require certain amount of that seed, and
Yes.
they will give you certain their forms are there. You have to fill up those forms, and they require certain information, some information on that material, and that material definitely that will be assisted by certain scientists. I mean, like you can assist of
Yes.
your local scientist, and they will ask certain questions, certain questionnaire that kind of format is there. You have to fulfill that, and that required quantity of seed is
Yes.
you have to deposit. And definitely they will, after some time they will, because farmers, for getting protection for farmers variety is not a problem. Absolutely, there is no problem. They are getting, I mean, a lot of material I have shown here. I mean, you must have seen that my slide. A lot of
Yes.
material has come from this farmer side. A lot of varieties are coming. Or I know in Manipur, a lot of varieties are there, local varieties are there.
Yes.
So you can get that, and you can
Yeah.
assist these farmers.
For
Yeah.
further this one clarification, I will discuss. I'll contact you. Now,
Yeah, yeah,
I if I take so much
sure.
time and others will feel
Yeah, yeah.
bored.
I'm
Uh,
happy to see you.
yes,
Nakumaryam.
thank you
Yeah,
so
yeah,
much. Thank you so
yeah,
much,
yeah.
sir.
Thank you, thank you, thank
Okay,
you, thank you.
okay, thank you so much.
Thank you, ma'am. Thank you, sir. Next, I would like to call Piyush Kumar Yadav. Kindly unmute yourself.
गुड इवनिंग सर।
Yeah, good evening.
सर मेरा एक छोटा सा सवाल था, मतलब लिटिल बिट कंफ्यूजन है कि सर हम जैसे रिसर्च आर्टिकल या कि रिव्यू ऑफ लिटरेचर, बुक चैप्टर, ये सब हम लिखते हैं तो ये हम अपने लिटरेचर के बेसिस पे, यानी कि जो हमारा कहीं थियरी लिखी हुई है उसके बेसिस पे कुछ लिखेंगे या प्रैक्टिकल के तौर पे लिखेंगे?
नहीं, आप जो देखिए, आप बाहर इंफॉर्मेशन जो आप लेंगे, जो भी आप लिखना चाहते हैं, एक तो होता है उसमें जो मटेरियल आप ले रहे हैं, वट एवर मटेरियल यू आर गेटिंग एज ए रेफरेंस मटेरियल, राइट? जहां से भी आप मटेरियल ले रहे हैं, उसका आप सोर्स मटेरियल, आप सोर्स रेफरेंस, वो आपका एक तो होना चाहिए। उसका सोर्स रेफरेंस से उनका इंफ्लुएंसेस। आप क्या एमएससी पीएचडी स्टूडेंट, एमएससी स्टूडेंट है? यू आर
यस सर,
एमएससी,
यस सर।
एमएससी स्टूडेंट, राइट? तो आप जो मटेरियल, जो भी आप काम जिस पे भी लिखना चाहते हैं, आपने जो सिंथेसाइज किया आपके दिमाग में, उसका आप सोर्स मटेरियल लीजिए, रेफरेंसेस आप कलेक्ट करेंगे, उससे इंफॉर्मेशन लेंगे, इन्फ्लुएंस उससे निकाल के कि भाई और आप क्या कहना चाह रहे हैं, और वहां से पहले स्टडी ऑलरेडी क्या है, आप उसको अपनी स्टडी के साथ में इंटरप्रिटेट करेंगे, राइट? कि भाई उन्होंने ये कहा है और हम, मेरा ये है कहना, और उस तरीके से कोई स्टडी इस तरीके से मिल रही है या नहीं मिल रही है। अगर मिल रही है तो आप कहाँ डेविएट कर रहे हैं। तो दोज काइंड ऑफ थिंग्स, वो जो आप उसमें लिखेंगे, अब आप उसके लिए क्या करना है, एक सिंपल वो है कि आप दो चार पेपर पढ़िए पहले। आप रिसर्च आर्टिकल उस पर जो भी आप लिखना चाहते हैं उसको पहले पढ़िए आप पूरे। जब आप पढ़ेंगे तो आप ऑटोमेटिकली आपके दिमाग में आ जाएगा कि भाई मुझे क्या लिखना है अब इसमें, अब मैं क्या लिखना, मैं जो लिखना चाहता हूं उसको किस तरीके से एक्सप्रेस करना है। वो आप 5-7 पेपर जब पढ़ेंगे तो आपको ऑटोमेटिकली आइडिया आ जाएगा। फिर आप उसको सिंथेसाइज करिए, उनका रेफरेंस जहां आपका फिट हो रहा है वहां रेफरेंस दीजिए, और इसको इंटरप्रिटेशन कंक्लूजन लेके आइए। यही होता है,
जैसे
सिंपल।
सर मेरा जैसे सर मेरा सॉल्ट टॉलरेंस इन अनियन स्क्रीनिंग पे हमारा प्रोजेक्ट चल रहा है, थीसिस। तो सर हम उसका कौन कौन सा पार्ट या पूरे थीसिस में या रिसर्च में हम क्या क्या पब्लिश करा सकते हैं?
देखिए, आप सॉल्ट टॉलरेंस पे तो आपके जो जीनोटाइप्स आपने लिए हैं, नंबर ऑफ जीनोटाइप्स आपने लिए होंगे, स्क्रीनिंग की होगी, सॉल्ट का डिफरेंट
बिल्कुल।
लेवल लिया होगा, ईसी लेवल लिया होगा, राइट?
जी जी जी
है
जी।
ना, डिफरेंट ईसी लेवल पे लिया होगा। सेलाइन, सोडिक सॉइल, जो भी वाट का आपने वाटर का लिया है, किसका लिया, डिफरेंट ट्रीटमेंट्स आपने लिए होंगे। देन नंबर ऑफ
बिल्कुल
आप, व्हाट इज योर फील्ड, यू आर डूइंग
सर,
एमएससी।
हॉर्टिकल्चर वेजिटेबल, एमएससी
बेस्ट है,
हॉर्टिकल्चर।
ओके ओके, हॉर्टिकल्चर। सो डिफरेंट लेवल पे आपको स्क्रीन आउट करना है, राइट। अब नाउ उसमें आपको रिसर्च पेपर जब देखेंगे, आप उसी पे आर्टिकल सर्च करेंगे तो आर्टिकल मिल जाएंगे आपको। उसमें ऑलरेडी स्टडी कुछ न कुछ हुई होगी, ऐसा नहीं है। तो फिर आप देखिए कि वो जो स्टडी हुई है और मेरी स्टडी जो मैं कर रहा हूं, वो कहाँ डेविएट कर रही है और कहाँ सिमिलर है। तो वहां से आपको आइडिया मिल जाएगा, जहां डिबेट कर रहे हो वो आपको कंक्लूजन में लेके आना है कि भाई मैं ये कहना चाहता हूं, तो उसका वो आपकी एक थोड़ा सा उसमें यूनिकनेस आपके वर्क में आएगी कि भाई मेरा थोड़ा हटके है वर्क इससे, ये है, यहां तक सपोर्ट कर रहा है। सपोज एक 1 फीट का आपका वो है, रिजल्ट है, तो आप कहोगे कि मेरा आधा फीट तक तो सपोर्ट कर रहा है या 600 मीटर से सपोर्ट कर रहा है, इसके बाद मेरा नहीं सपोर्ट कर, बट ये मेरा यूनिक है, दैट इज यूनिक। तो उस यूनिक को आप उनको सपोर्ट लेते हो, उस यूनिक को आप कंक्लूजन में लेके आएंगे, जो भी रिजल्ट आपका डिस्कशन होगा, तो वो फिर आपका आपकी स्टडी एक बढ़िया हो जाएगी, आपकी एक अलग स्टडी होगी। तो वो है दैट इज। तो वो जो एक्चुअली क्या है, ये आपका रिसर्च आउटपुट। तो रिसर्च आउटपुट, रिसर्च रिजल्ट आउटपुट है, राइट। तो रिसर्च रिजल्ट का जो आउटपुट है वो आपको दैट में बी यूटिलाइज फॉर डिफरेंट पर्पसेस, फॉर क्रिएशन ऑफ न्यू नॉलेज। आपका पेपर हो सकता है कि आपने जो पेपर लिखा वो एज सच एज ए प्रोडक्ट आपका कहीं एज ए आईपी में नहीं आ रहा, या बट दैट कैन बी यूज एज ए बैकग्राउंड आईपी, एट दिस कैन बी यूज टू यूटिलाइज टू क्रिएट न्यू रिसर्च, टू न्यू आइडिया, राइट। सो
आइडिया।
दैट वुड बी कंसिडर्ड एज ए बैकग्राउंड आईपी। एक होता है बैकग्राउंड आईपी, एक होता है फोरग्राउंड आईपी। So foreground IP is the output, final output of your IP, right? Whatever the research results. And background IP is whatever you are going to do, what kind of research earlier somebody has done that has been utilized for developing your new research, new result, right? So that is background IP. तो वो रेफरेंसेस वगैरह होता है ना, वो बैकग्राउंड में आ जाता है। तो ये इस तरीके से होता है। वो हो सकता है आईपी आज आपकी प्रोडक्ट नहीं दे रही है, आज आपकी आईपी एज ए प्रोटेक्ट नहीं हो सकती है, या मतलब कॉमर्शलाइज नहीं हो सकती है, बट कल को वो आईपी कहीं ना कहीं किसी का कॉमर्शलाइजेशन होगा, उसमें आपकी आईपी का कहीं ना कहीं यूटिलाइजेशन हो सकता है, 12%, 20%, 30% कहीं ना कहीं यूटिलाइज हो। सो इसीलिए हर चीज की इंपॉर्टेंस है, ठीक है ना।
सर जैसे कि मान लीजिए कि अभी तो हमारा थीसिस चल रहा है, बाकी हम
हम्म।
कुछ सर पब्लिक्स वगैरह कराते हैं, जैसे एब्स्ट्रैक्ट हो गया या बुक चैप्टर। तो सर देयर आर सेवरल टॉपिक्स जो बहुत लोगों ने ऑलरेडी यूज कर रखा है। तो क्या हम उनके सेम टॉपिक पे एज अ रिव्यू या सेम टॉपिक पे अपना जो ओपिनियन है वो लिख सकते हैं?
नहीं, अपना ओपिनियन मतलब उनका जो आपको रेफरेंस तो लेना पड़ेगा ना, आप उनके बैकग्राउंड रेफरेंस जो होंगे, आप रिव्यू लिटरेचर लेते हैं ना, रिव्यू लिटरेचर लेंगे, फिर
हम्म।
आप उसमें से देखेंगे कि हमारे इससे रिलेटेड कौन कौन से एग्जैक्टली जो है, थोड़ा सा सिमिलरिटी दिख रही है, बट हमारा अब आपका थोड़ा सा डिफरेंट तो होना चाहिए भाई। ऐसा तो हो नहीं सकता कि आपका किसी का भी रिजल्ट किसी का सेम तो हो नहीं सकता। अगर आपको सेम हो रहा है तो कॉपी कर रहे हैं आप, इन्फ्रिंजमेंट हो रहा है वो। भाई उनको
जी
दूसरी
जी
भाषा
जी।
में अगर आईपी की भाषा में बोलेंगे तो दैट इज काइंड ऑफ इन्फ्रिंजमेंट, अगर आप किसी की चीज को कॉपी कर रहे हैं, राइट। आप कॉपी नहीं करना है, बट आइडिया आपका उनका है, आइडिया का आपको ठीक है, आपका उनका आइडिया, आपकी जो आप नया आइडिया जो जनरेट करने जा रहे हैं या कुछ भी लिखने जा रहे हैं, उसमें उसकी हेल्प मिलेगी। बट ये नहीं कि वो डिट्टो आपको कॉपी करना है, उसके मल्टी सोर्सेस ऑफ आइडियाज, उनको सिंथेसाइज करके नाउ यू हैव टू अपने आइडिया के उसमें फिट करना है, वो किस तरीके से, देन आप अपने कंक्लूसिव रिजल्ट पे पहुंचेंगे, ठीक है ना। वो कुछ भी हो,
ओके।
वो थीसिस है, कुछ है, थीसिस में भी तो होता है ये, भाई हम रिव्यू लिटरेचर लेते हैं, फिर देन रिजल्ट डिस्कशन में जाते हैं, तो रिजल्ट डिस्कशन में क्या है, वो हम सपोर्टिंग वाले देखते हैं कि एग्जैक्टली सपोर्टिंग रेफरेंसेस कौन सा है। फिर उसके बाद हम अपना कंक्लूड करते हैं कि यस वी हैव डन दिस, है ये है और इन्होंने भी बोला है, बट हमारा भी ये इस तरीके से आ रहा है। तो थोड़ा होता है ना, तो वो है, बाकी सिमिलर तो कुछ नहीं होता। सिमिलर है तो वो इन्फ्रिंजमेंट होता है, वो कॉपी होता है, वो कॉपी कर लिया आपने।
बिल्कुल। सर ऐसा कोई मतलब अभी फिलहाल वेबसाइट या टेक्नोलॉजी से हम प्लेगरिज्म को चेक कर सके, जैसे कि अभी?
ये तो ऑनलाइन आपकी यूनिवर्सिटी में लाइब्रेरी में होगा, जरूर देते हैं आजकल तो सभी जगह प्रोग्राम
हाँ
ले
जी
रखे
सर,
हैं।
लाइब्रेरी में, बिल्कुल लाइब्रेरी में तो है सर। ओके।
Yes.
Thank you, sir. Thank you, sir, for your kind information.
Okay. Okay.
Thank you, sir. Sir, actually, I impressed the way you are today is delivering the session and the knowledge you have. Seriously, not only me, I think all the participants will agree with me that your explanation and way of handling the question and answers. Seriously, we all inspired by you, sir. Now, before I
Thank you.
conclude, I would like to call Mr. Ajay Kasana, Chief Secretary of Agri SAARTHI, to share his remark.
Okay, thank you, Dr. Vijay. So, Jai Hind. So, thank you so much, Dr. Siddharth, for such an in-depth and
Thank you.
detailed
Thank you.
session you have delivered today. Basically, हमारे जो मतलब बच्चे हैं या फिर जो वर्किंग प्रोफेशनल्स हैं, मेहनत बहुत करते हैं, लेकिन कुछ नॉलेज की कमी की वजह से वो पेटेंट्स नहीं करवा पाते और अपने जो क्रेडिट है वो नहीं ले पाते हैं। तो इसके ऊपर आपने बड़े अच्छे तरीके से जो बातचीत की है कि हाउ दे कैन गेट द perks and privileges for their intellectual property. So really it was a great session and we really blessed with your presence today, sir. So thank you so much, Daksa.
Thank you. Thank you, sir.
Yeah, Dr. Vijay, please conclude the session.
Okay, sir. On behalf of the Agri SAARTHI team and all the participants, I extend my sincere and heartfelt gratitude to Dr. Shiv Datt, sir, Principal Scientist, for delivering an exceptional, insightful, and thought-provoking lecture on intellectual property rights and technology management in agriculture. Sir, your lucid explanation of IPR concepts coupled with the real-world examples for agricultural research and innovation has greatly enhanced our understanding of how intellectual property safeguards creativity, accelerate technology transfer, and strengthen the agricultural innovation ecosystem. Your guidance and on managing technologies from lab to land was both enlightening and highly relevant for researchers and students. We are truly grateful for your time, expertise, and wisdom you shared with us. Your session has inspired us to think strategically about protecting innovations and responsibly translating the research into impactful agriculture solution. Once again, thank you so much, sir, for your invaluable contribution and for making this session a memorable and enriching experience for all of us. My sincere thanks also to our organizing director, Mr. Ajay Kasana, sir, Chief Secretary of Agri SAARTHI, for his continuous support, meticulous planning, and guidance, which ensured the smooth and successful conduct of today's program. I take this opportunity to thank all the participants for their enthusiastic participation, active engagement, and thoughtful interactions, which truly made the session lively, meaningful, and successful. I also place on record my appreciation to the entire Agri SAARTHI team for their dedication efforts in organizing this 30-day National Agriculture Training Program and for consistently providing a valuable platform for learning, capacity building, and professional development. Before we conclude, I kindly request all the participants to ensure that the attendance form which has been shared in the chat box is duly filled. Please note that submission of the form is mandatory and the link will be remain active only for 30 minutes. Once again, thank you all for your valuable time and participation. We look forward to your continued association and active participation in the forthcoming sessions of Agri SAARTHI KRANTI 2020. Thank you, sir.
Okay. Thank you. Thank you, all the organizers. Thank you. I extend sincere thanks to all the organizers for arranging such a nice this program and giving me this opportunity. Thank you. Thank you all. Thank you, Mariam.
Thank you so much, Daksa.
Thank you. Thank you, Dr. Kasana ji. Okay.
Thank you so much, Daksa.